into another episode of DOJRP Life. Today we're getting in, as you can tell by the music, as the illustrious, the notorious Mr. Goley. We have a case of one of the Lost MC members in the live server. Mr. Goley is a criminal defense attorney, and he is contracted out with the Lost MC Motorcycle Club, and we are getting in to handle one of the cases for one of the club members, Mr. Jack McLinger, aka Mehoff. We have, he has charges against him for obstruction of a government employee, aggravated assault of a government employee, reckless driving, reckless endangerment, all tied into a bank robbery that occurred a few weeks back. So without further ado, let's get into it and see if we can't get him clear of these charges.
Good dog.
Hello, how are you?
I'm all good, bro. What about you?
I'm doing splendid. Looking forward to clearing my client of all of his charges this fine evening.
You British?
Yes, from Manchester.
Oh, really?
Yes, originally from Manchester, spent most of my life growing up in the orphanages of London, down in the south side.
Which part of London?
It's hard to pin down one specifically because I moved around.
East Islington, Kent, Essex.
I would say more around Kent because like I said, growing up, I kept bouncing from orphanage to orphanage, so it's not too easy to pin down a specific part of London. I was a vile product of the orphanage system, unfortunately. Mother and father died at a very young age.
Yeah. You know, you do a really good voice, but Kent isn't a part of London.
Well, that's the last orphanage I was in before I went off to uni, was Kent. So, I mean, that being the last orphanage I was in, I guess I would have the most claim to being from Kent. Even I was born in Manchester.
Oh, shit. What hospital?
I'm not sure. Most of my records were lost in a fire.
Oh,
I just
okay.
know I was born in the city of Manchester.
Right. Okay.
Most of my childhood and growing up is not really well known to me because most of the information was lost, or I just didn't pay mind to remember it.
Okay.
Baby girl,
Sounds sweetheart.
how you
Don't
doing?
think I've had the pleasure of meeting you personally, sir.
This is my
So,
main
boss,
homeboy, Mark.
I'm Mark.
Pleasure to meet you.
Yeah, I pulled Mark's ass out of trouble more times than I can count.
Listen, bro, you went with a British lawyer. That's offensive as fuck because you know what British lawyers
The
are
name's
about.
John Goley, Viper Industries. Oh, sorry.
He's
Did
You
just-
don't want to enjoy that.
he's a club lawyer. And personally, I'm gonna take all the help I can get.
Yes, I'm a criminal defense attorney, and I only work for the organizations of this fine state.
Right. Yeah, but if you ever go to shake my hand again and a needle pops out, I'm gonna beat your ass. All right.
I would highly recommend you not try to do that, sir.
I'm joking.
A viper's bite is very dangerous.
He's not a humoritive type like Mark. You gotta tread easy. Just saying.
It's a gift from Mr. Simon Fiber that he left me. It's finicky. I'm still trying to get used to it.
Okay, no problem.
Is
I was
Simon
just fucking
still
with you.
kicking?
Just basically making sure if you're real Brit, you know, you do got that fight or flight.
Well, I did grow my my calluses on my hands in the underground bell knuckle rings in London, so I know how to handle myself in a savage fight. I wouldn't
Yeah.
say fair,
No,
because if
it
you're
was
not
nothing
if you're
against
not
you.
cheating, you're not trying. You know.
No, yeah, it was nothing against you like that or anything like that. It's just making sure you treat my friend well over here. That's all.
Of course, me and Jack go way back. I go way back with the club as well.
Oh shit.
Well, sir, it is getting
All
close
right,
for
well,
our appointment.
yeah. I'll be in the dock and I'll see you. All right.
All right, buddy, root for me. I'm gonna need it.
I got you. Nothing against you, Mr. Lawyer. See you later, bud.
Now, Mr. McLinger, like I said, do as I say. You don't speak and you let me do all the talking. Savvy?
Copy. I follow. Don't worry.
We'll stick to the game plan that we established at the clubhouse. And everything should go swimmingly.
Can we just run through it one more time out here? So I picked up a fuel load from the most
Vespucci
western,
Beach.
from Vespucci Beach. I
You were
was
heading
taking up
to
the 277.
277 Flywheels where you employed.
Yes.
And you were taking a half load of fuel to restock the fuel pumps.
Yes. I was taking a half load of their regular fuel since they were running low.
What's up, Leiden? Very good. Shall we?
Yes, sir, we shall.
Yes. It's the man of the hour. And it is a petrol station, and it's gonna bug me that's not wrong.
Mr. Ado, how are you, sir?
Oh, that's
Well,
crappy.
well.
It's been quite some time since we've crossed paths. Last time I saw you, you were up on the bench.
That's true.
I am good. I am
Well,
good.
best of luck to you, sir.
Ah. I'm just gonna wait and get and
All right, here we go.
I think if I tackle the back of his neck, he'll get mad. Like, if I go up behind Mr. Ado, just tickle the back of his neck, do you think he'll get mad?
Might as well say your neck.
Probably try and work hard at it.
Oh, yeah.
It's funny.
Alright.
Look at them lawyers sitting over there together.
So we're just
Mad.
waiting for the judges to come in here.
You got something against lawyers?
No?
Sounds like just making sure.
Hey, I shit talk everybody. Hey!
Yeah, I'll get shit
It's
talked from many
Smelly
people,
Boy Mark.
not from a woman who's an aluminium.
It's the correct pronunciation!
Yeah, I don't think it is.
Mark, they're dissing on our intelligence of pronouncing words.
You mean lack thereof?
They've spelled defense wrong. It's missing a 3.
I'm dyslexic anyway, so it's fine.
So am I.
Get off my
I mean-
seat, cum bubble.
Seat's taken.
Just sit on him, lad.
Oh, he left her.
Oh,
I thought I heard cum bubble as well. I ain't gonna lie.
cum bubbles?
think you heard
That's
right.
interesting. I mean, condom?
No, it comes with cum bubbles.
Yeah, you don't need those. You're a bit ancient there, Mark, right?
See, Mexicans don't know how to use condoms. They're like fucking chihuahuas. They pop out of nowhere.
Condoms are just overrated.
Huh?
You get nice close and personal with that one, Mark. Oh, I think I just spotted Ronald Kennedy in the window.
Medicine came for the.
All right. Sorry, gang. Had to talk to the boss lady that just got home.
Hey, it's Ronald! They don't want to sit next to each other. They look a bit lonely over there.
I mean, you go sit next to them, see what happens.
That Ronald, he smells fucking weird.
All rise.
Oh, shit.
I didn't take the pill today. Oh, yeah, Anna.
Send me the court song.
I'm
I'm doing it, David.
Alright, you can go ahead and be seated now.
Oh,
Yes, sir.
That's
Court's now in session for CR 1039 State v. McLinger. We can now begin with his opening statements.
Remove that helmet.
On the mouth.
Sorry, what'd you say?
Remove the helmet, please.
Oh,
Evening, Your Honor.
Good evening.
Bradley Ada for prosecution. So, Your Honor, this case is about an independent risk creation during an active felony pursuit.
sorry, what'd you
The
say?
evidence will show that the officers were pursuing multiple armed robbery suspects. The defendant chose to operate a heavy commercial vehicle within the immediate pursuit corridor near the tunnel entrance under the I-2. His vehicle was in motion prior to the final impacts. He maneuvered within the shoulder of the roadway rather than clearing the area. Contact occurred between his truck and a marked patrol vehicle occupied by a trooper performing official duties. The evidence will further show that the defendant did not possess a valid commercial driver's license to operate that vehicle. That vehicle itself was unregistered and uninsured. This case is not about who created chaos. It's about whether the defendant inserted himself into the chaos into a criminal, reckless manner and interfered with officers performing their duties. The state will prove that he did this.
Your Honor, people of this fine court. What the video evidence that you're going to see attached to this case shows is, and whether the state can meet the burden of each statutory element beyond a reasonable doubt, is what's come before you in this court. The defense submits that it cannot. Mr. McLinger was operating a vehicle making a fuel delivery truck, which, by the penal code, he did not meet the required weight limits to classify it as a commercial vehicle, thus only needing a Class C driver's license to operate the vehicle. His vehicle was struck by the subjects that law enforcement were chasing through, as the prosecution stated, the pursuit corridor. It's well known amongst the laws that if you see lights and sirens, you pull to the right side of the road, which is what my client was in the process of doing when the vehicle that law enforcement were chasing struck the front of his vehicle, causing damage to his truck, which hindered his ability to keep full control of that truck As you'll see in the evidence that was attached to the arrest report, not only was he involved with a collision of the subjects law enforcement was chasing, but also a law enforcement officer himself whose body and dash cam footage was used in these proceedings. My client had no control over said vehicle. He had heavy damage to the right side of his vehicle, which also damaged his braking system. This caused him to naturally roll forward uncontrolled and barely tap into the officer's vehicle. At the same time, there was an exchange of gunfire between law enforcement and the vehicle they were chasing. At no point in any of this did my client resist officers, try to impede them in doing their due diligence to protect the citizens of this state and of this city. I would also like to bring to the court's note that during this whole process, there was an issue where the arrest report that was used to find probable cause was not put into the system in a timely manner as appointed by the courts and the procedures that these law enforcement officers have to abide by. From past precedences, such as PC 1049 and PC 1042, when officers either amend or don't put these charges
Your Honor,
in a timely
Max
manner.
Foundation.
Say your objection again.
His argument lacks his opening statement's improper and therefore lacks a foundation to make that type of an argument.
Mr.
Probable
Gully,
co-
unfortunately,
probable
I would
cause was
have
determined.
to agree with
Understand, Your Honor.
Mr. Ido here.
The defense will withdraw that statement then. Clearly, the evidence will show that my client did everything in his power at the time to avoid being involved in this incident. And because of the circumstances involved, he did not have full control over the vehicle due to damage involved. Thus, law enforcement used this as a chip to bring forth these charges, and we will prove beyond a reasonable doubt that my client is not guilty of any of these charges.
Objection.
Mr. Ido?
Your Honor, before we start addressing the statutory elements, the state will establish the uncontested factual frameworks in this case. On the date in question, officers were engaged in an active felony pursuit where the patrol vehicle was marked and occupied by a government employee performing official duties. The defendant was operating a commercial tanker or truck near a tunnel entrance during the pursuit. That by itself establishes the setting in which he shouldn't have been there. I'm not sure what fuel delivery he was performing on an open area, but the video timeline clearly states that, you know, as the dashcam sequence chronologically states, that the defendant was positioned near the tunnel entrance with the wheels facing forward, and then as the suspect's vehicle was going through the entrance, the defendant moved his vehicle forward to the right-hand face in an attempt to clearly block the vehicle. We have since dismissed the charges of conspiracy as well as robbery against the defendant because, as the defense said, there was nowhere a way to us to show that. But that being said, the patrol vehicle then did make contact as the vehicle was moving forward already, and attempting to close the gap to close off the pursuit vehicles from the suspect vehicle. Under Title 8, the question in which is whether the defendant demonstrated a willful or wanton disregard for the safety of operating a motor vehicle. Here, the defendant was operating a heavy vehicle, commercial vehicle, during an active armed pursuit. He maneuvered within the immediate pursuit corridor, and then rather instead of clearing it, vehicular contact occurred. Additionally, his record shows that he does not possess a CDL license for this operation of a vehicle, and therefore the totality of the circumstances demonstrated wanton disregard for the safety of everyone around. And I would like to note to the court that he was already pulled over to the side on the right-hand side prior to
Could you put that
the
tablet
contact
away?
of law enforcement, as the pursuit did go opposite lanes of traffic in opposite directions.
Huh?
Thank you.
Wait, I'm not allowed to sit on my.
No.
Under the Penal Code of 116, the issue is whether the defendant engaged in conduct creating a substantial and unjust risk. Operating a multi-ton, I won't even say commercial, but in general, operating a multi-ton vehicle requiring specialized licensure during an active felony pursuit creates an obvious risk. The defendant did not possess that licensure. He nevertheless chose to maneuver within the pursuit corridor. That conscious decision in that environment satisfies the reckless disregard. Even if there are other actors moving at speeds, multiple individuals can create independent risk. Under 408, the court considers whether the defendant intentionally interfered with a government employee performing official duties. Officers again were engaged in actively pursuing an armed suspects towards the tunnel entrance. The defendant again moved, as stated before, in their path. Even temporarily interference during an active pursuit qualifies as obstruction. Intent may be inferred from deliberate vehicle movements within a known pursuit corridor. And for the final count, Your Honor, under 109A, a motor vehicle can constitute a deadly weapon when used in a manner capable of causing serious and bodily harm. As the defense has said, the truck hit another vehicle.
Fuzz
that can be
197 coming in with
construed
that
as
follow. Thank you.
causing serious and bodily harm, as
family.
the truck is much heavier and much more dense than a standard patrol vehicle or even another car in terms of tonnage. The patrol unit was occupied by a government employee performing official duties. The defendant's commercial vehicle made contact with that patrol unit. At minimum, the conduct was reckless. Reckless use of a vehicle capable of causing serious bodily injury against an officer satisfies that requirement. I don't know if the defense plans to play the video or we want to watch that, or if we've all seen that.
I used to be
Bailiffs, if you could figure out who that was.
What? That's quite funny, honestly.
Your Honor, defense would like to point out specific instances in the video dash cam footage from the officer. If we do need to replay that for a refresher for everyone in the courts, by all means, we are pleased for that to take place.
Yep, we can get the footage loaded up. So, Mr. Ito, do you have any objections to playing the video?
No objections, Your Honor.
Someone started playing the objection hearsay video.
Don't mind me.
Damn!
Jesus
You're gonna take the driver out of this truck now.
He's got common sense there. That dude is annoying.
One down, one down.
Move.
One down, one down.
Move.
Are they shooting?
This is Zachary Kane's annoying ass.
742 on the highway, the little side entrance.
Alright.
Damn, he's just laying into them.
Damn, he went just for. He's looking
He's
to
just
kill.
going. That poor guy on the motorbike, man.
Ma'am, if you cannot control yourself, I will have you removed from my courtroom.
Mr. Gully. I don't know if it happened for you, but I couldn't see the footage from mine.
I could. It's all right, Sam. It was viewed.
Are you putting it on, or am I putting it on?
No, it was already played, Mr. Ado.
Oh, okay.
Mr. Ado, do you need it played a second time?
No.
Mr. Ado, do you have more to speak on?
I do not, Your Honor. State rest.
Mr. Gully?
Yes, Your Honor.
The floor is yours.
Yes, sir. I would like to make note that at 10 seconds in the dash cam footage, we can see the fuel truck my client was driving to make his fuel delivery get in a collision with the black Gator, which law enforcement seemed to be chasing as their suspects for this situation that was ongoing.
Your Honor, I object to lack of foundation for the fuel delivery. The defense has provided no information showing that he was on a delivery run.
Nonetheless, my client was in a fuel truck, and there was a collision with the black Gator, which law enforcement were chasing after. My client had heard the sirens and seen them coming and pulled over to the side of the road in the footage before the Gator made collision with his vehicle. Then at 12 seconds, you can see that my client's truck had sustained heavy damage to the front right, causing issues. As you could see in the video, his wheels were turned hard right. My client reported that he had steering issues that he reported to law enforcement, but it was not documented. At 13 seconds, we can see that the people in the black Gator that was being chased by law enforcement began to open fire, and there was gunfire exchange between law enforcement and LEO. Between the subjects in the vehicle and LEO. Then at the 29-second mark, you can see my client is cooperating fully with law enforcement officers, while law enforcement continued a gunfight with the subjects they were pursuing. At no point did my subject try to resist these officers, try to obstruct them in their duties of taking care of the situation that they were involved with. My client was in a truck that had sustained damage, causing him difficulties to prevent his vehicle from striking an officer. And as you could see, it rolled forward and barely touched the officer, which I'll leave it to the court's interpretation if that is enough to justify assault with a deadly weapon. And these are the key facts that I wanted to point out in the dashcam video that was provided. The defense would rest.
Mr. Ido, if you have no rebuttal, do you have a closing argument, sir?
Your Honor, the question before this court is not whether this was a chaotic scene. It was. The question is whether the defendant conducted independently created criminal liability. The evidence shows he operated a heavy commercial vehicle requiring specialized licensure without possessing that licensure.
Objection.
He did so
Objection,
during
Your
an
Honor.
active.
There was no inspection of the vehicle to determine that it met the requirements under 10.1 of being a commercial vehicle. There was no weight conducted by a CVE officer, so there's no way to know if it was over the 26,001 weight requirement for it to be classified as a commercial vehicle. And as Mr. Ado also pointed out, there is no evidence to show that my client was making a fuel delivery, so there's there's nothing known of what its contents were in the tank itself.
Since one of the charges is not driving a commercial vehicle without a CDL, I'm gonna overrule that.
He did so. He did so during an active felony pursuit. He maneuvered within the pursuit corridor near the tunnel entrance. Vehicular contact occurred with a marked patrol vehicle occupied by a trooper engaged in official duties. Even if others are moving at speed, that does not negate the defendant's conduct. Multiple actors can contribute to the risk. Recklessness requires conscious disregard of substantial risk. Operating a multi-ton commercial vehicle in an active armed pursuit corridor satisfies that standard. The elements of 109A, 116, 408, and 424 have been met, and the state respectfully requests the finding of guilty. Thank you.
Mr. Gully?
Your Honor, as we've seen from the evidence provided in the arrest reports, the dash cam footage, there is one question that did occur that came up from this. Was it made clear who the officer was that the footage came from, whether it was Officer Breeze or a different officer? If the prosecution knows the answer to that question.
Objection, relevance.
The relevance says it's being reported to me that this footage is used by an officer that's no longer in the state, and the defendant has a right to face his accuser, sir. Which, if he's no longer here, then would it not deem this footage irrelevant?
It would not.
Understood, Your Honor. That answers my question. Now, I'll say this. As we saw in the footage, my client was trying to abide by the laws of the state, pull over to the right, and yield to law enforcement. He was struck by the vehicle they were chasing, causing heavy damage, as seen in the footage, to his truck, causing control problems of said vehicle. And then after that collision, the officer vehicle came into the scene and also had a collision with the subject they were chasing and my client. At no point did my client try to resist, try to obstruct. He was trying to do what any law-abiding citizen would do. Get out of the way, stop, yield. Because as you see in the video, the first officer comes in, and then shortly after there's a whole bunch of other officers. Where is he supposed to go? They're all coming down the road towards him. He can't safely maneuver out of the way and go opposing lanes of traffic like they did to get to where this subject was and where this officer was that needed his help. My client did the best he could in that current set of situation that was presented to him. Move over, get involved in a wreck. The best thing he could do is stop and do what the law enforcement officers instructed him to do. If that is grounds to say that he assaulted an officer or obstructed the officer in the line of duty, then that is a major issue, Your Honors. I let the evidence speak for itself. My client did everything he could at that very moment, and I asked the court if there is anything else that he could have done. We would like to know the answer to that. Defense has nothing further, Your Honor.
Yeah, no, I'm gonna object on lack of foundation in terms of him pulling over. The video clearly shows at 11 seconds he's already pulled over to the side of the road.
Your Honor, defense would like to counter with it, stating that you can see he's pulled over because there's a vehicle coming opposing lanes at him, and the officer is coming down the on-ramp chasing after him. So it is safe to assume that the officer is chasing this truck that's coming at him. So why not pull over and stop?
Your Honor, it's safe to assume that's hearsay. It's counsel's testifying.
I would say that's not as hearsay. The court will take a brief recess as while I discuss, and I'll be back with a ruling by 10:10 Eastern Standard.
Excuse me.
Again.
He's
You
the one that brought it in.
Nah.
Yeah, I wish it was. Technically, those can be blurred out.
So his main argument on the one case is that it was a vehicle, CDL required vehicle. That's the reason why he was hit with that charge. That's
Yes.
That ruling is not a good ruling.
No, it is not.
So, but you should have said, Your Honor, this is a two axle vehicle. If the front axle is 8,000 pounds, which most commercial vehicles are 8,000, if it's not a semi, most of the larger vehicles, the front axle is 8,000 pounds, then it has to be at least 18,001 pounds for the rear axle. But they didn't. They haven't proved what that vehicle is.
Oh, I heard quite a few objections for the audience.
So.
Should have definitely been louder.
I would like to know if Agent Breeze's testimony in the arrest report is based off of his own viewing, or if that's based off of body cam footage.
All based off of what officers reported to him.
Yeah, off of what other officers reported to him. Correct.
There's way too many holes in this case, and it is hard to pinpoint.
Because if it's based off of other officers' testimony of what was pointed to him, then it's hearsay. It wasn't his direct testimony. And if he is putting hearsay into that, that's going to bring into question any reports that he's ever done. Because essentially, if you can get him to admit on, in oath, while he's under oath, that he is going off of other officers' word, then it's hearsay. It's also, and you're going to love this, it's also perjury.
Yes, well, unfortunately, there were no witness lists submitted for this case. It's all based off of that dash cam footage.
Oh, gotcha.
How much of a chance do you think we got at winning this?
Is it not?
No, this is the trial.
Oh, this is the trial.
PC was found already.
Oh, Jesus Christ.
Such a chicken.
Yeah. I would have made him put fucking Breeze on the stand. If trial. Had I known this was the trial, I would have been like, "Where's Breeze?"
It's okay. I'm going to get from my PC hearing in 17 days. I don't.
Yeah, for some reason I thought this was the PC here. Yes, my love.
My biggest thing I'm aiming for is at least get these damn felonies off your record.
Yeah, which was it that was a felony?
Obstruction of government employee and aggravated assault against a government employee.
Oh.
They really like aggravated assault. Intended murder.
How you doing, Jack?
Oh, I'm doing fine.
I don't know why I hurt.
I just want this shit to be over with.
Ow.
Yeah, tell me about it.
Trouble.
Yes, my love. What'd you do?
I think she's got a boo-boo.
You have a boo-boo.
Where?
I jumped into the pool and I have a boo-boo.
Where?
My shoulder.
I feel better.
Woo-hoo-hoo. Yeah. I can wait till that report's done to go to the hospital.
Okay. Are you hurting right now?
Yes.
Gosh.
I decided
you mess
to.
around?
I don't know.
What the fuck?
And I owe Mark 20K.
Iron EMS is not around. You want me to take you to the hospital quick?
Nah, can wait.
You sure you're not gonna die on me, are you?
No. The pass
Yeah,
out would be
IFAX to
funny.
hold you over?
Yes. If pass out would be funny. Do a harbor breeze and pass out. I'll do a bee-hoff and pass out. Ooh, I wonder.
Yeah, I mean, like I said, the fact that he's saying, "Oh, it doesn't matter. He wasn't charged with driving without a CDL," like that's their main argument for that. Oh, and you could have said, I do have the person that owns the gas station here that he works for. Speaking of which, I need to edge you.
Yeah, this is fault on my part. There's things I could have been more prepared with for this. It just took so damn long to get this actually before the judge. And then the judge said that a defendant doesn't have the right to face his accuser.
Oh wait, the judge, yeah. we got about 5 minutes. Do we want to go back in?
I suppose so.
Which one?
The one I closed.
Oh, I don't think I saw that.
For the robbery.
Oh,
The robbery,
yeah.
Yeah, that one.
Got
I
it,
couldn't.
got it,
I just filed for dismissal. I couldn't do it for that one.
Yeah. Okay. Well, let's we'll get through it and we'll go from there.
No, not yet.
Should we all just stand like right here?
It's fucking creepy.
Nice boots you got on.
Is there any more body worn camera footage you need for anything that you're processing right now?
They just got assigned. Oh, Mr. Brown got assigned at 1051.
Oh,
Need to look into. I need to look into 1048, 1047 more. I don't have those. I haven't looked at those yet.
Oh, I'm not on those yet. Those DOJ.
Everyone, please return to your seats.
I gotta go. Good luck.
All rise.
Be seated.
No.
You're still sad anyway.
If no final statements, this court is now prepared to render judgment.
Nothing further, Your Honor.
Defense rests its case, Your Honor.
Mr. McLinger.
Stand up, Jack.
On count 1 of Title 1, Section 9, Subsection A of aggravated assault against a government employee, this court finds you not guilty. On count 2 of Title 1, Section 16 of reckless endangerment, this court finds you guilty. Of Title 4, Section 8, obstruction of a government employee, this court finds you guilty. On Title 8, Section 12, reckless driving, this court finds you not guilty. this court, it imposes no additional fines or no additional jail time. Court is adjourned.
No, right? Stop.
Okay.
Right? Yep. Mm-hmm.
Well, that's interesting.
That was interesting. Huh.
Mr.
You
Ido,
at
I
the
believe we have
hospital
a
now?
follow-up.
We do, Your Honor.
So
The
back to,
civil probable cause hearing. I believe opposing counsel's here too.
Who is opposing?
Oh,
Jones?
James Jones for the defense, Your Honor.
Is your client here, Mr. Jones?
nothing.
Yes, Your Honor. My client.
You're just dead.
objection. I can't smell your butt. I need to hospital.
Yeah, I'll get you.
What?
Right.
Wait for me.
So next step is
How did he find not guilty? On
That's
the,
fucking stupid.
On the
Reckless driving, but guilty
no,
for
I'm
reckless
saying, how did he
endangerment.
get you on the how did he get you on the reckless endangerment, but not guilty on the assaulting itself?
And not only that, but I didn't obstruct in any way. I was fully fucking compliant. Corruption.
Ow.
yeah, he was guilty for reckless endangerment and obstruction, not guilty on aggravated assault and reckless driving.
So I do have a felony on my record then.
Okay.
Now, right?
Ooh.
You're arresting me.
Yeah, the reckless.
Can you do it times 2 prongs?
No,
know,
it's
one of
the
my ass.
obstruction.
How the... Where did I obstruct at?
Reckless endangerment is classified as a misdemeanor.
Yeah, I would have liked the clarification on the obstruction charge.
Can we appeal the ruling?
We can.
We got lawyers, right?
All right. So come here.
Yeah, we are.
Oh, yeah.
We can and we will. As well as I can also file a motion for mistrial because Elio's
He said that you didn't have the right to face your accuser.
that, and also that for the grounds that he allowed law enforcement to update the MDT when in the past it's been past precedences, all charges have been dismissed with prejudice in all of those cases.
It'll be interesting to see.
So I have some work to do. I'm going to request a DOJ with a full detailed breakdown of why he was found guilty. Why you were found guilty on the charges you were found guilty on. And submit submit the.
Did you say you need a lawyer?
Who needs a lawyer?
You,
And then,
you were
you know,
asking if,
submit
if we were lawyers here.
the motion to appeal
No, I said we
the
have
guilty
lawyers.
verdicts, and then
Oh, we have lawyers.
Because I was
here.
joking around that I was gonna arrest her because she tackled me.
and also file the motion for mistrial.
Yeah.
What's
I
this?
was messing with her. Stop poking at things. No.
Her ADHD's kicking in. Don't worry. Well. Yeah, I don't know what to tell you on that one. I still would have made. I would have made him get on the stand. Breeze.
Yes, well, no witness lists were requested or submitted, so.
Doesn't matter. If Breeze was there and he was able to do it, you do have the right to face your accuser. If they didn't bring him, if they didn't, yeah, if they didn't produce him, then that's on the state.
Well, I guess I'll get those motions.
And he was in court, so.
Well, I'll get all the motions put together and get those filed. And if Hauser tries to pull this shit that I'm the Chief Justice and usually my rulings aren't appealable, then I'll hit him with fucking constitutional law.
Yeah.
And if he still
They'll probably
refuses,
pull that one.
then I'll
Trouble,
I'll
we gotta
sue
go.
the fucking courts for violation of constitutional rights.
What did you do?
Fuck with Matthew's radio.
Oh, jeez. All right. I gotta get
I
her
gotta
to
get
the
the
hospital.
All right. So
I need to go to the hospital.
All right, King. That's where we're gonna wrap up this episode. Yes, we won, but we lost. We got some stuff that we have to, some motions and stuff that we have to file for this. We're gonna file an appeal. We're also gonna file a motion to, for a mistrial to be declared due to the fact that they allowed for LAO to amend the MDT after their allotted time to put their arrest report in the MDT, which violates past precedents that's been made by the court system thus far. And we'll go from there and see what happens. But thanks for hanging out with us. Keep putting on the hard work, because one day will pay off, and we'll be back one day. Take care, everyone.